Our second case today, case number 19-1444, Bailey versus Women's Public Health. Counsel, are you ready?
May it please the court. Get the microphone situated. My name is Paul Donovan, I'm in Gross, based in Gainesville, Florida. We represent the appellate, Dr. Bailey. I understand the marshals put down a 3-minute warning for me, so I may reserve that time for rebuttal.
Very good.
Your Honors, Dr. Bailey never agreed to arbitrate claims of the parent entity or any related entities of his employer. He only agreed to arbitrate with his employer, who I'll refer to in this oral argument as WPH, Women's Pelvic Health. I'll refer to the parent as FWCU, and that's consistent with the briefing. Seifert from the Supreme Court in 1999 teaches that a party cannot be compelled to arbitrate a dispute that it did not intend by its contract to arbitrate. The order under review denies Dr. Bailey the right to a jury trial on his common law defenses against indemnification for the parent or FWCU's settlement agreement with the United States Department of Justice. The appellee cannot use the shield of arbitration as a sword to deprive a jury trial where that was not clearly intended. The record evidence in this matter is undisputed, it is uncontradicted, and shows only a claim of liability by FWC, the parent, due to its settlement agreement with the United States Department of Justice.
On that, I'm looking at the claimant's claim statement from the record. Paragraph 8 of it says that Women's Public Health seeks to have Dr. Bailey indemnify it for its claims, etc., that it incurred as a result of the actions of Dr. Bailey. So it seems that the statement of claim is WPH and Dr. Bailey.
Your Honor, paragraph 3 of the statement of claim directly contradicts that, and all of the information and evidence obtained, and the only evidence in the record in this case, establishes that liability only attached to FWCU, that there was absolutely no liability, claim, demand, money owed by Women's Public Health to FWCU.
But does that go to the the ultimate merits of whether Women's Public Health actually has a loss, which would be, it seems, an arbitration issue versus it claiming that it does have a loss in this statement of claim?
Well, it could initially seem that way, but that deprives the court as the gatekeeper of the initial 3 elements of whether arbitration is required. Essentially what it does is it eliminates the second requirement of the court to make a gatekeeping determination of whether the claim is arbitrable. The fact that there is absolutely no evidence whatsoever in the record to support even any arguable basis of a claim is not sufficient. Conclusory allegations such as that, which are devoid of any factual predicate, even in the allegations, would not be sufficient to make the claim an arbitrable claim.
But on the face of taking the face of the statement of claim, for what it's worth, your client originally went into arbitration and started litigating it, isn't that correct?
Yes.
And it was only after there was an appearance that there wasn't any evidence to substantiate the claim that then decided to challenge this arbitration.
Absolutely.
So I don't understand the answer then that a facial analysis, if it's contradictory, would serve as a basis to determine whether this thing was arbitrable or not. When on just facially, didn't your client waive a defense about arbitration?
Oh no, absolutely not. Because I don't believe that the standard is whether there's a facial analysis of the claim. Normally, these cases and the precedent cases that are talked about by the parties in the brief deal with a complaint that is filed by a plaintiff that has factual allegations, not mere conclusions. And then the issue of whether the matter is arbitrable is before the court at the early stages based on the filing of a lawsuit and whether that lawsuit should be sent to arbitration. I think Dr. Bailey was in the posture of reading a complaint for arbitration that suggested that there may be some liability. But the moment that he learned that it was not founded on any evidence, no claim whatsoever, not even addressing the merits, there's not even a colorable claim by WPH that they had any claim to arbitrate, and in fact, that paragraph 3 of the statement of claim, which deals specifically with what the facts are, is that the claim was by FWCU, the parent. And you can't forget that FWCU and FWPH both filed the claim for arbitration. Dr. Bailey immediately moved against the claim by FWC because there was no contractual basis to arbitrate.
But doesn't this all start with, so there was a False Claims Act investigation by DOJ against the FWC. They settled. Then they are coming after the pelvic care entity. Presumably that's their assertion that they want, based on billing practices, they want indemnity from your client's employer, based on his billing and other people's billing.
FWCU.
Yeah.
That's right.
But in the statement of claim, though, they're at least suggesting on the face of it that the billing came from your client's employer to FWCU, and that was the basis for the False Claims Act investigation.
Or part of it.
Sure. And then in his contracts, your client's contracts with his employer, there's references about indemnification for billing practices, and then there's, how does that not then at least facially arise from these contracts?
Well, because what it does is, well, it may facially arise from that contract, but then what happened is we learned that there was absolutely no demand, no anything from FWCU to WPH. There's absolutely no evidence of that. If there was some evidence or some allegation even, that should have been presented against Dr. Bailey's motion in the instant matter. There's absolutely no evidence whatsoever to suggest this position that WPH owed anything to FWCU. And what that would do is it would vitiate Dr. Bailey's ability to raise common law defenses against FWCU regarding indemnification.
What do we do, though, following up with Judge Osterhaus's question, Judge Tannenbaum's questions, plural, what do we do with Section 682.03.4, and I quote, "The court may not refuse to order arbitration because a claim subject to arbitration lacks merit or grounds for the claim have not been established." That sounds like it's simply a facial determination, and if there's not evidence for it statutorily, the trial court can't use that as a basis to deny arbitration. Or are we reading that incorrectly?
No, I don't think you are. However, it does not allow for the court to disregard the evidence in the matter. And if the only claim is a conclusory claim without any factual predicate, which is what we have here, we have a barely conclusory allegation in the claim statement, and then the paragraph 3 of the claim statement, which says the only liability attached to FWCU, then you have to delve further. So, for example, when it becomes apparent that the claim that is made, that is bringing the case to arbitration, has absolutely no predicate, not that it doesn't have any merit, but that it has no factual basis that would withstand a motion to dismiss, for example, or a motion even for summary judgment. It's got no factual predicate, that the matter should not be allowed to continue to arbitration.
Well, wouldn't that, again, back to the statutory provision, wouldn't that mean it lacked merit? I'm using the words of the statute, or grounds for the claim have not been established. That's what you're telling us happened here, and that's not a reason, according to the statute, for the court to deny arbitration.
The difference is the grounds or the merits have not been alleged factually. There is not even a bare scintilla of a factual allegation.
But was your client got involved with, when your client initially participated in the arbitration, he acknowledged that there was a facial basis? I mean, then see, at the hearing, it was at 221 of the record in the transcript, there was an acknowledgement, well, we couldn't have sought a stay at the time because we took the plaintiff or the claimant at their word that there was a basis for the claim. So isn't that an acknowledgement that just on the face of and this is what I was asking before, on the face of the statement of claim, that there was a basis, that your client acknowledged there was a basis for arbitration?
I would suggest that my client admitted that there was a possible basis, but then when it was discovered that there was no basis, it was brought to the court's attention. For example, if it was determined later, and this was not the case in this case, Dr. Bailey was not attacking the arbitration agreement itself, which are the precedent cases that the appellee relies on in arguments on waiving. He's attacking the claim of substantive, whether the claim is arbitrable. If it is learned that there is a problem with the arbitration agreement and the arbitration agreement was invalid, the case should not have sent to arbitration, the court would still have the authority to stop that case from proceeding to arbitration. I mean, the Florida Arbitration Code does specifically contemplate the court staying involved in the matter and being able to make these decisions throughout the proceedings. So it's not as if the question is only addressed at the outset. I think the appropriate approach here was to proceed based on the allegations made in the statement of claim. We moved to dismiss out the parent, FWCU. We proceeded in a very limited discovery to determine whether there was even a scintilla of an allegation or an argument whatsoever that would support the conclusory allegation. And the conclusory allegations are normally not sufficient to allow a matter to proceed.
But isn't your use of the language possible claim versus an actual a merits claim, isn't that the same as saying, I mean, that's what a complaint is. Any complaint filed in court is a possible claim. That's the allegations that the plaintiff is making that they think, as a matter of law, supports entitlement to relief. And then you go into the merits, and then it's ultimately resolved whether there was a basis for that in the evidence or not. Your client agreed to have an arbitrator determine ultimately the merits of, even if it's ultimately a basis claim, didn't your client ultimately agree to have an arbitrator make that determination?
My client agreed to go into that arbitration process and was taking the allegation, the conclusory allegation at that point as sufficient. As soon as it learned that the conclusory allegation was not sufficient, it resorted to Dr. Bailey resorted to the right to be able to go to the court to say, no, that conclusory allegation, which alone would normally not be sufficient, it doesn't have any basis. We believe that if they're making an allegation, perhaps there is a basis. And then when going into the arbitration with the very limited discovery was done, deposing the agent of both of the entities, Dr. Sudbury, he confirmed that there was absolutely no liability owed by WPH. There was no proof of that.
Counsel, you have about 2 minutes left under your rebuttal time, so.
Thank you.
Good morning, and may it please the court. My name is Alyssa Corey on behalf of Applee Women's Pelvic Health, who I'll refer to as WPH. This court should affirm the trial court's order denying Dr. Bailey's amended motion regarding the arbitrator's jurisdiction because the trial court correctly concluded that WPH's claim for contract indemnification was within the scope and presented an arbitrable issue under the employment agreements. Dr. Bailey's argument relies upon the premise that the trial court was entitled to make a determination as to the merits of WPH's contract indemnification claim. But that was not the question before the trial court. The question before the trial court was whether WPH had an enforceable agreement to arbitrate, not whether it incurred liability. Pursuant to section 682.032, when an arbitration has begun or been threatened and a party alleges that there is no agreement to arbitrate, the trial court is to determine whether there's an enforceable agreement to arbitrate and then order the parties to arbitrate. We can all agree that WPH cannot and is not entitled to arbitrate the claim of FWCU, but that's not what WPH was seeking to do, as noted in paragraph 8 of the claim statement, which seeks contract indemnification under the employment agreements.
We discern what kind of issues are arbitrable versus not arbitrable.
When looking at whether an arbitrable issue exists, you have to look about whether there's a sufficient nexus between the contract containing the arbitration provision and the claim. And so a lot of the cases that deal with determining whether the claim has a sufficient nexus to the underlying arbitration agreement, usually some type of employment contract. But here, it's clear that there's a sufficient nexus between the employment agreement containing the arbitration provision and the claim for contract indemnification contained within that agreement.
So if it looks more like the claim that your client is making arises out of the contract versus, say, a tort claim, Dr. Bailey backed into your client's sign or something like that, would that scenario be an arbitrable issue?
No, because you have to determine whether the claim, the tort claim, could arise out of or be concerning the arbitration provision. And so if there's no sufficient nexus between the underlying claim that's asserted and the contract containing the arbitration provision, then there's no arbitrable issue.
So this is an arbitral issue because it arises out of the contract, it deals with billing, something related to billing, and thus it makes it an arbitrable issue.
Yes.
Well, to take Judge Osterhaus's hypothetical one step further, let's say that Dr. Bailey was driving a company car, a car owned by a practice, and backs into someone else's sign. The owner of the sign comes after the practice for a claim, and then practice goes after Dr. Bailey. Is that an arbitrable claim?
Depending on the facts, it could be, because, or it could not be. It would depend on whether he was acting within the scope of his employment. And, a case that's relied upon by the appellant deals with whether an assault that took place on a parent company's dorm provided under the employer was presented as sufficient nexus to the employment contract, and the court determined no, that wasn't a sufficient nexus.
Sure, but let's assume that in the statement of claim it's very general.
Yes.
It doesn't mention any of those facts. It just says, hey, we're the practice, and this other person, this third party, is coming after us in a claim based on something you did, Dr. Bailey. We want indemnification. Cite the provision in the contract for indemnification.
Yes.
Is that enough? Is that arbitrable at that point?
Yes.
Without any facts whatsoever?
Yes, because the underlying basis and merits for the claim, whether WPH actually incurred liability under its contract indemnification and could seek that indemnification from Dr. Bailey, is something to be decided by the arbitrator.
Go ahead, finish your, sorry.
Once the arbitrable issue has been established under an enforceable arbitration agreement, then the trial court has to send it to arbitration, and then the merits, whether the allegations are sufficient, all of that gets bared out in arbitration.
So seeking indemnity on anything, it could be baseless, it could not be baseless. It could be based on something else in the contract one of Dr. Bailey's activities under the contract, or it could not be. The mention of indemnification by itself, or the provision in the contract, would that be enough to make it arbitrable, even if it were otherwise a baseless indemnification claim?
No, I'm not sure that it would, but here the claim statement has additional facts that would support the contract indemnification. It was clear that in paragraph 3 that the actions of Dr. Bailey contributed to the settlement. And so then WPH's claim for contract indemnification relating to Dr. Bailey's action in the scope of his employment is what is bared out in the claim statement.
All right, so it's not your position that mentioning the indemnification provision alone would be enough to make it arbitrable. That by itself wouldn't be arising under the contract. It'd have to be indemnification plus some reference to something that otherwise would be connected to the contract. Is that the position?
Yes, because when we're looking at the sufficient nexus, you know, we have to look at what the claim is for. And so if there was no reference to anything else, and it was solely one paragraph that said under the indemnification provision, you know, unless that indemnification provision stated that they were seeking for the actions of Dr. Bailey within the scope of his employment, and then you would be able to reach an arbitrable issue. So the facts of the claim statement matter when it relates to the underlying claim and its connection to the arbitration agreement.
And it could take a while to spin that out into arbitration discovery as to what's really going on, who owned the car, who owned the sign, for instance. And so that the idea of a waiver just because you enter into the arbitration process or into discovery, it may be a dynamic type standard.
Yes, and the waiver issue is something that's made in addition to the arbitrable issue. And so whether, and I mean, if we're looking at Dr. Bailey's discovery and what it was aimed at, it was aimed at the merits of WPH's claim. Do they have a claim? Can they present it? That is a merits determination, not a jurisdictional determination as to whether there is an enforceable agreement to arbitrate.
So on the statement of claim here, so now we're going away from hypotheticals to this case, based on the answers you've given so far, we have clearly they're seeking indemnification in the statement of claim. What is the actual basis? What aspect of the contract is your client seeking arbitration on?
And that is specifically that pursuant to the employment agreements and the pivoting owner agreements, they're having, WPH is seeking to have Dr. Bailey indemnify it for the claims, actions, demand, and loss that it incurred as the result of Dr. Bailey and his actions.
But specifically what? Because that gets back to what we were talking about before, the hypothetical. That's a general statement. What specifically were his duties that implicated, how does this indemnity claim arise from the contract? What is it the billing practices? Is that the assertion that the False Claims Act investigation in some way related to his billing practices that was passed through, I guess, your client and then passed on to FWCU? Is that
Yes.
theory?
Yes, and the underlying terms of the settlement and the parties involved does not extinguish a claim that WPH may have in relation to the settlement agreement. And so the basis for WPH's indemnification claim related to the settlement and the billing practices of Dr. Bailey arise out of the employment agreements with WPH, and that's a basis that will be parsed out in arbitration.
And is that, and part of that, is that because Dr. Bailey in the contracts agreed to assign all his billing to your client to then handle however they do through third parties or Medicare or anything else?
Yes, when we're looking at the relationship between FWCU and WPH, they're affiliates. And so Dr. Bailey's billing and submissions are made under FWCU's tax ID.
Well, but does that matter whether they're affiliated or separate business entities?
Right.
So they could not be affiliated.
Correct.
But does that change the theory or the analysis?
I don't think it changes the theory of the analysis, no, because they're wholly owned subsidiaries and they each have independent claims. And so the fact that FWCU's claim in arbitration was extinguished doesn't mean that WPH doesn't have an independent claim that is the subject of arbitration under the employment agreements.
Well, I mean, so regardless of whether they're affiliated, is there anything in the record that indicates how the billing went from your client to FWCU? Like how is it that FWCU is coming back at your client in the first place regarding the DOJ investigation?
And what you're describing is exactly the type of discovery that would take place as to the merits of WPH's claim in arbitration. And so the claim statement itself is sufficient on the facts relating to the settlement, Dr. Bailey's actions arising under his employment, and then WPH's seeking to have it indemnify it as a result of the actions of Dr. Bailey under the employment agreement.
Well, but what if Dr. Bailey, so let's assume Dr. Bailey has knowledge of these relationships and how the billing works, and he gets this claim from his employer, hey, this other practice is coming after us because they just settled the DOJ investigation, and we want you to indemnify us for it. And he's thinking, well, I don't see the connection, because I know that my billing doesn't go to FWCU. I don't have anything to do with that. I give you my bills, and then you do whatever with them because it says that in the contract. Is he supposed to, I mean, has he agreed to arbitrate even that question? Like the threshold question of this doesn't make sense because I know that I don't have anything to do with the billing that goes to FWCU.
Yes, under his employment agreement, he would have agreed to arbitrate that claim. And so, say there wasn't a sufficient basis for the claim. In arbitration, you move to dismiss, move for summary judgment, and it's over. What we're looking at here is the scope of getting into arbitration, whether there was an enforceable agreement to arbitrate and whether it was an arbitrable issue. Once those are established, everything else gets parsed out of the merits in arbitration. So if this court has no further questions, I would ask this court to affirm the trial court's order regarding arbitration. Thank you.
Your Honors, there's nothing in the record, not even an allegation of fact, that exists regarding the billing practices. Paragraph 8, which could be the only basis for an argument of a claim of arbitrability, is a general conclusory statement without any factual allegation predicate. Using it alone for a court to determine whether this is an arbitrable issue is insufficient. Now, the court was not asked to determine, and nor is it required to determine, whether an arbitral claim exists before the arbitration proceedings commence. And so the courts have addressed situations where the issue of arbitrability is raised after an arbitration proceeding commences. And hence we have the argument of waiver. That's really why that argument is there and develops, meaning waiver by Dr. Bailey of the right to contest the arbitration and request his right to litigate. In the precedent cases cited, the only cases cited that where a court denies the ability of, denies the claim attacking the arbitration are cases where a party, Freelick is an example of that from the fourth DCA, is an example where a party filed counterclaims in the arbitration, so therefore conceding that the arbitration agreement was valid. Then afterwards goes to the court to say, wait a minute, this arbitration shouldn't proceed because the arbitration agreement itself is invalid. Here, Dr. Bailey is not attacking the arbitration agreement. Dr. Bailey is attacking the second prong, that there's no arbitral claim based on the information that's obtained. There's not even a scintilla of an argument in the record whatsoever to support any kind of even allegation that WPH had any liability from anyone, whether parent or Department of Justice, and the Department of Justice settlement conclusively establishes that it did not, because WPH was not released, Dr. Bailey was not released, they were not required to pay a penny in the settlement agreement to the Department of Justice. And we all know the Department of Justice, if they wanted it, could have gotten things from those entities and didn't. And then when Dr. Bailey learned, he filed his motion.
Thank you, counsel.
Thank you very much. We would ask that you reverse. Thank you.
We are going to take a brief recess.